The cops have created a search warrant loophole to get your information. They can just buy it. After 20 years of practicing law and dealing with more than 10,000 criminal cases, this is one of the most troubling areas I have seen. Why would the Supreme Court allow this to happen? And what can you do to defend yourself from it? The Fourth Amendment is supposed to prohibit the government from performing unreasonable search and seizures. After all, this is the reason why we have search warrants. In fact, the government is only allowed to perform searches on private property if they have a valid search warrant, which is great. Search warrants are supposed to stop a local sheriff with a grudge, or maybe an FBI agent, from kicking down your door, searching your house, and looking for whatever they want. But when it comes to your cell phone data or your internet browsing history, the government has found a way around needing a search warrant. They don't have to ask for permission anymore. They can just buy your data. I agree. This is crazy. So how did the Supreme Court allow this to happen? First, let's explain public versus private. Court rulings have said there is generally no reasonable expectation of privacy for information that you voluntarily share with others. But the cops need a search warrant for private information. So for example, the government needs a search warrant in order to intercept your private phone calls. But because you share the phone numbers you dial with your phone company, which they need in order to complete the call, the government can now get that list of public phone numbers you dialed from the phone company without a search warrant. This is known as the third-party doctrine. The government can compel a company to hand over public information without a search warrant. In 2018, the Supreme Court had a case of Carpenter versus the United States. In this case, law enforcement obtained a week's worth of location information from a robbery suspect's cell phone service provider without a search warrant. As the Supreme Court saw it, this was a violation of the Fourth Amendment because a lot of private information was obtained without a search warrant. So the Supreme Court narrowed the third-party doctrine and ruled that because Mr. Carpenter had no choice but to share his location information with his cell phone provider, now the police must obtain a search warrant in order to get it, even if they share that information with a third party, as long as the information being shared is sensitive and that it is effectively mandatory to do so. Okay, great. So now police cannot compel cell service providers to hand over your location data. And if they really want it that bad, they're going to be required to legally obtain a search warrant before they can use any of it against you. But then law enforcement and intelligence agencies realized there are lots of other companies out there that provide location data that are not cell service providers. What if we just buy the data? And suddenly, the Fourth Amendment loophole was born. Since Carpenter versus United States was decided, it's very common for both law enforcement and intelligence agencies to buy Americans' data through commercial data brokers. While this practice violates Carpenter's spirit, if not its letter, law enforcement lawyers continue to argue that a warrant is only required if they compel a third party to produce your information. However, they argue no warrant is required if they just pay for your data. Using this flimsy justification, law enforcement agencies continue to buy your data, and it's incredibly sensitive. Several law enforcement and intelligence agencies, ranging from the FBI, the Department of Homeland Security, and the Department of Defense, have purchased your cell phone location information without a search warrant. And the worst part is, cops and intelligence agencies are using your tax dollars to do it. So is anything being done about this? There are attempts taking place in Congress with the Davidson-Jacobs bill to stop this loophole of obtaining evidence without a search warrant. So, is there anything you can do to defend yourself? First, be careful what you post on Facebook and social media and other providers. And what if the cops do show up to your house with a search warrant? Be careful, they'll exploit another search warrant loophole. The search warrant is supposed to lay out exactly what they are allowed to search. But if you allow the cops into your house, they will begin to not only search everywhere, they can tear up everything, and they can use everything against you even if it went beyond the scope of the search warrant. So, you should say out loud, I do not consent to any search of a person, place, or thing that is not specifically authorized in the search warrant. Then, keep your mouth shut. Once you make it clear that you do not consent to anything that is not expressly provided for in the search warrant, you are now providing your criminal defense attorney an opportunity to file a motion to suppress so that they can go in and potentially exclude any evidence that was not authorized by that search warrant. And did you know that cops also found a loophole to the Fifth Amendment? Check out this next video where you will learn that remaining silent could actually end up getting you in more trouble. See you there.